Good morning, and I'd like to first welcome all of you to the 6th edition of the OECD Competition Open Day. Our first panel will evolve around the consumer welfare standard. And maybe starting with if we would have done a survey asking competition authorities what are they doing, basically, I think it would be fair to say that most of the answers will evolve around protecting competition, promoting competition. But if we ask them, why are they doing that? What is the purpose? What is the standard that they are using? Well, there things might get a bit more complicated. It would be fair to say, I think, that consumer welfare standard would be very high on the list. But other replies might be also possible. For example, some competition authorities have been mostly focusing on total welfare standard. In recent years, we've seen the rise of new standards, new competitors in the market for competition standards, like the protection of the competitive process, which is gaining a lot of support, especially across the Atlantic. Of course, the challenges competition authorities currently need to face have made this discussion ever more complicated with, for example, the rise of digital platforms and the type of risks they are bringing with them to the competitive process, the role that competition enforcement and policy should or maybe should not play within the green transition, and the role that competition enforcement should play in labor markets. So is the consumer welfare standard still fit for purpose? Do we need to revise it? Maybe do we need to replace it? To answer this question, or maybe just to discuss it, I have with me here 3 leaders of major competition authorities, and let me start by presenting them. So to my left, Olivier Guersent, the Director General for Competition in the European Commission. Sarah Cardell, Chief Executive of the CMA United Kingdom. And joining us virtually is Andrea Marván, Chairwoman of COFECE Mexico. So thank you very much, all of you, for being here with us today. And we'll start with the general question: is the consumer welfare standard still fit for purpose? So Sarah, would you like to go first?
Thank you so much, and thank you for the invitation to speak today. It's fantastic to see so many of you here in person and obviously many online as well. So I guess I would sort of pick up quite a lot of the themes, actually, of the discussion this morning already. When we think about the consumer welfare standard, I mean, it's absolutely a relevant analytical framework for us, but I don't think we approach things applying the consumer welfare standard in a very narrow or prescriptive way. So maybe just to sort of unpack that a little bit. If I take a bit of a step back, for the Competition and Markets Authority in the UK, we're both a competition agency, also a consumer protection agency. And our sort of statutory duty is to protect competition for the benefit of consumers. So obviously we have that built into our statutory duty. We've thought quite a bit about how we bring that to life. How does that really translate into the work that we're doing in practice? And so we have sort of set out our purpose, explained our purpose as being to promote competitive markets and tackle unfair behaviour for the benefit of people, business, and the economy. And we've done that very explicitly because we want to make sure that we bring out the totality of the impact that we can have as a competition agency and the different sort of constituent parts that we serve. We serve people, we serve businesses, and we serve the economy as a whole. And we also very much think about those things as complementary. So they're not in tension. You know, sometimes I think as a competition agency, we get asked, well, if you're pro-consumer, are you anti-business? Where are you making those trade-offs? We don't see those trade-offs arising. We think that if we are serving our purpose in promoting competitive markets, that benefits people. Obviously, it benefits people as consumers. It may benefit people, for example, as workers as well, and I'll come back to that. But it also benefits the many, many businesses that are seeking to compete and innovate and thrive in those markets. And so we've sort of taken that a little bit further and thought, well, what are the outcomes that we are seeking to achieve? So for people, we're seeking to make sure that people can get great choices, fair deals. For businesses, we're seeking to make sure that that vast number of large and small businesses can innovate and thrive and compete. And again, picking up some of the themes of the earlier discussions, we think that we have an absolutely critical role in supporting the wider economy, to support a productive, a sustainable economy, to create competitive markets where competition can thrive, but also that support growth and innovation and investment. So as a competition agency, my starting point is not the application of the consumer welfare standard. My starting point is, what are we here to do? What are we here to achieve? How do we do that? How do we drive those benefits in those different ways for the different elements of the sort of stakeholders that we are here to serve? It's also, though, I think very important that we do that through the toolkit that we have. There was a comment earlier about sort of not straying beyond our remit, and I think that is important too. So we have to operate applying the competition laws, in our case, also applying the consumer protection laws. And of course, that varies a little bit. So for us, we have merger control. We're looking at mergers. Is there a substantial lessening of competition? We have our Competition Act enforcement, which is breaches of competition law, anti-competitive agreements, abuse of dominance. We have the ability to look at how well competition is working across markets as a whole, and that becomes perhaps a slightly broader lens through which we can look. So it's not the sort of the narrow assessment of, is there a breach of competition law in that case, but how are the markets working? A good example of that actually is the report that we put out last week on the house building market in the UK. Now, house building is absolutely critical for people to make sure that they can get somewhere to live, somewhere affordable, somewhere of decent quality. But it's also critical for the economy. To support a productive economy, you need to have a house building market that works. So in that case, we looked at some elements of competition that weren't working well, some elements where consumers were not well protected. But actually, the fundamental issue in that market in the UK is about the planning system and how the planning system is working. So we felt that we had a role there as an objective competition agency to call out issues that we saw in the planning system, but it's clearly for the UK government in that case to resolve those issues. So it's important, I think, to recognise the role that we play, but also the boundaries of that. And I think, coming back to what does that mean in practice and how do we apply the sort of economic frameworks when we're looking at how well competition is working, when we're looking at whether there are breaches of competition, whether a merger will give rise to competition concerns. It's really important that the analytical framework that we're using is grounded in the reality of the markets that we're looking at. And we hear that, I think, I'm sure Olivier and Andrea will say something similar, and we certainly hear that from our colleagues in the US as well. I think there has been a real shift over the last few years, probably particularly in merger control, in making sure that that analytical framework really matches with the market dynamics at play. So we see that in relation to digital markets particularly, not exclusively. Where are the parameters of competition? Again, we've had it earlier this morning. Is it price? Is it quality? Is it innovation? And making sure that we can look at capturing the potential detrimental effect or impact of a merger or impact of an anti-competitive agreement on competition. It's not just price effects. It's not only those immediate effects on consumers. Consumers can be harmed in many, many different ways, short-term, long-term. Quashing innovation now can impact on consumers in years to come. So I think we apply that consumer welfare standard in the way that we do our work, but we apply it, I think, in a very broad, adaptable, agile way, where it's really making sure that we can capture the full range of different impacts, different sort of elements, dynamics of competition, different ways in which competition can be harmed, and through that, obviously, ultimately, consumers can be harmed, whether it's in terms of the immediate impact for consumers in downstream markets, whether that's the impact that they feel ultimately by damage to innovation, growth, and other effects. I could go on, but I'll maybe pause there for now.
Thank you very much for now. Olivier, would you like to go next?
Yeah, thanks. Well, I think I share the view that Sarah just expressed. I mean, it's not really our starting point is not, oh, what is the standard we're applying? But it's fair to say that at least in the EU, I don't think we ever had a pure consumer standard. But actually, if you read the competitive chapter of the treaty, it rather protects competition as a process. And there is a reason for this. And this is that the EU competition law has always had two goals. One is the protection of consumers. The other one is the integration of the single market. So I've always thought that EU competition law, if you have to define a standard, it protects allocative efficiencies. It protects the ability of market to efficiently allocate all resources. And of course, consumer welfare is quite a good proxy for that. So I mean, it's, you know, nothing is black and white in life, and even less in competition policy, I would say. And that is certainly the case there as well. But that explains why we never really had in the EU a narrow price-based only competition standard. So when I read, there is a lot of literature at the moment on how wide the American standard has become and how restrictive, arguably, is the EU standard. It's a bit astonishing, to say the least, because I think this is specifically because our standard was not a narrow consumer standard, has never been. We don't have a restitution standard, unlike in the US, for example. That we were able to adapt, maybe quicker than others, to the evolution of the market. New theories of harm are focused on innovation, for example, already 20 years ago. I mean, Mario mentioned it. Does that mean that has nothing to do with the consumers? No. I mean, Article 101, paragraph 3 is very clear about the fair share for consumers. Whereas in the merger regulation, say clearly that the merger regulation is here to protect consumers. So, but it's not that clear. And certainly, if you want to make a determination, I would say we have a relatively broad consumer welfare standard. I guess you announced the topics you intend to cover. We will explore the limits on how broad it can be, because that's the issue. Innovation is pretty clear. It's almost as clear as prices. And then the more you go towards out-of-market efficiencies, the more we need to have a discussion, I guess. So, yeah, well, this is what I would like to say by means of introduction, I guess.
Okay. Thank you very much. So we have heard so far from the UK and the EU that they apply, let's say, a wider version of the consumer welfare standards. And Andrea, over to you now, how things look from Mexico.
Hi, Ori. Hello, Sarah and Olivier. I'm sorry I can't be there personally, but I'm very happy to be here with you this morning. I think I could take it a little bit of a step back and maybe start at why competition policy even started in Mexico. Our competition policy laws are a bit newer. They've just turned actually 30 years last year. And the reason for creating enforcement in competition policy in Mexico 30 years ago was basically as a result of negotiations of the North American Free Trade Agreement. So even though there was a mandate to eliminate and fight monopolies in our constitution, we actually didn't have enforcement of competition policy until 30 years ago. And it was the result of the North American Free Trade Agreement, which was basically, as I'm mentioning, a condition in order to have a competition agency, but also I think with a more traditional focus on market efficiencies and to protect the competitive process. As a result, and I'm not just saying this has happened only in Mexico, I think it's also, I would say, a trend in other jurisdictions. The consumer welfare standard or overall standard has maybe shifted, as Sarah has mentioned it, and or even made it a little bit more broader. I would say that's understandable. It seems, or at least from our point of view, it seems that the discussions about competition and their benefits and consumer welfare standard or efficiencies have been, I would say, a little bit or highly technical and maybe in a closed environment, which have generated some questions about, or from the general population, about what has competition policy, or what is competition policy doing for me? I think the consumer welfare standard and the benefit of consumers have always been there. However, it hasn't been that clear, or until a few years ago, where the conversation about the importance of competition, its impact on consumers, and in small and business enterprises, or in creating economical development, have now been or become much more inclusive in how competition can actually enhance the general population's daily lives. As a result, or what have we done again in Mexico? There has been a big evolution to our competition laws, but not only to our competition laws, but also to our competition, I would say, enforcement, in order to make competition policy a tool that actually brings tangible benefits to consumers. How? First, on focusing our enforcement and advocacy efforts in sectors or markets that actually impact households and household budgets, such as food, energy, transportation, healthcare, financial services, which if you now look at our current investigations, they are basically focused on these types of markets. In Mexico, for example, we have done studies that the poorest households, or the households with less income, pay about 15 to 20% of surcharges due to the lack of competition in basic goods and services that they consume. Secondly, and it's also something that Sarah has mentioned, by engaging with small and medium-sized enterprises to understand the challenges that they face, and how competition policy can help them enter a market, compete in a market, and ultimately drive innovation, entrepreneurship, and economic developments. So I do agree that the concepts of competition and the consumer welfare standard has always been there. However, I do believe that its definition and how competition agencies analyze it and use their current toolkit has become broader.
Thank you very much, Andrea. And yeah, let's now maybe get into the more tricky stuff, because when all the interests push in the same directions, things are easy, but when they push in different directions, things might get complicated. And as a first example, maybe we can take digital markets that were mentioned by you and also in the keynotes. And there are maybe two potential examples. First, the strong emphasis on non-price features. Namely, we can mention privacy in this sense. You mentioned innovation. How would you analyze, would you measure traditional harmful competition, let's say a price increase, against a profit to innovation, or the chance of having more innovation? And second, in the EU, we already have this additional layer of competition, rules, ex-ante rules, to regulate digital markets. The UK is, let's say, seriously considering adopting a different, but in a sense similar, layer of regulation. And again, what's the rationale behind them? Do they all push in the same direction necessarily? And if they're not, and I think it would be fair to say that in some cases they do not. How do you make the balance? So Olivier, would you like to go first?
Yeah. So since the first Microsoft case, it's now 25 years that we are enforcing strongly competition policy in the digital world, and it comes with its challenges. I mean, they're numerous, they're well known. Multi-sided market, very often no price, as you said, Ori, which doesn't mean you do not pay, but you pay with your data. That creates a small difficulty for economists to quantify the effect. Huge network effects and markets that are prone to tipping. So what do you do with this? And it is true that we have faced in a number of the cases the argument from the parties that what they were doing was enhancing consumer experience. So what is wrong with buying and integrating a number of new services that could have turned into competing services, because that enhances consumer experience, yes. But on the other hand, that entrenches the power that these gatekeepers derive from their core market. Because anything that could potentially be one day or the other become a competitor, even if it's not yet, is bought and integrated into the. So, and this is a difficult debate, of course, and it has to do, in the end of the day, with what do you consider to be, well, how broad is your concept of consumer welfare? But even if you take a broad concept, you still have to make a judgment call. And this judgment call is in the end of the day, specific to the merits of each of the cases, I would say. Let me take one that now everybody tells me is, yes, of course, it's obvious, etc. But at the time, everybody was telling me, oh, it's very daring, you will lose this case in court, and that is Google Shopping. In Google Shopping, well, basically, is it a problem or is it enhancing consumer experience that other comparators than Google's are in page 36 of the search results? Well, both. Of course, it's very convenient for the consumer, but on the other hand, Google killed the comparator market, and any competition that could have come from this market, we thought this was anti-competitive. We didn't have to decide whether it is on the consumer welfare standard, because we believe our standard allows us to protect the competitive process, and this was the basis for the decision, and it was confirmed by the courts. You could take a number of other cases, Google Android. To a certain extent, you could take the very, very recent case, Apple Spotify. It's also both. But we're fortunate enough not to have to choose and to explain clearly in what is it satisfying a narrow or not so narrow consumer welfare standard. Now, if I turn to mergers, I think it's in a way even more interesting. It's more recent, and it's a bit more terra incognita as well. And that allows to start to explore the boundaries of what we could and should do. Because I'm personally very, very confident for as long as you can develop an innovation theory of harm. For me, it's almost as close to the core as prices, as price effects. When you go to other externalities, it can become more tricky. For example, are the competition authorities in charge of applying a standard that encompasses data protection or privacy protection? To what extent should we also do the job of the privacy regulators? And that was a question, for example, in Google Fitbit. Because in Google Fitbit, the issue was very much about the concern about Google being able to access health data of the users on top of all the other data they can already access. And also, the reason why we decided that we could take care of it is because, of course, that was influencing the capacity of other manufacturers of wearable products geared to health to be competing in the market. And the result, as you know, was a data silo. And then the second question is how good this is to have not completely structural remedies, et cetera, et cetera. But that, in my view, is a good example, because if it had been just about protecting privacy, with not a strong hook into the protection of a competitive process, I don't think we should have taken care of it. Somebody else should have, the data protection authorities. So I think it's for competition policy as for many things. If you assign to the instrument too many objectives, you're likely to miss all of them. So I'm rather a believer into trying to do the job in terms of protecting competition, competitive process, and in the end of the day, consumer welfare, rather than trying to go for an all-encompassing view of competition policy. More recently, if you go in booking e-travel, it's also interesting, because in that case, this is about booking, buying a platform for reserving flights and transportations. So it's non-horizontal. It's kind of ecosystem type of theory of harm. But what was interesting in that case is that by the own internal research of booking, a non-horizontal case would have resulted into a raise in the market shares, relatively substantial, which is interesting. They attribute that to the stickiness of the consumer. Once you have entered the ecosystem, you know, it's Hotel California. You can check out anytime you like, but you can never leave. And that was the issue here, because that was, of course, protecting further, entrenching the power of booking onto his core market. So is this consumer welfare? Is the protection of competitive process? Again, probably a bit of two. And I could multiply the examples. So I think one of the reasons why the Commission was successful in its action in the digital sphere is precisely because we were not within a closed environment of strictly defined consumer welfare standards.
Thank you very much. And Andrea, before you take the floor, just to pick up on something that you've said, Olivier, and maybe Andrea can address it. You mentioned at the beginning that when you have this conflicting interests, you need to decide on a case-by-case basis, and then you provided a few examples on how to do that. And I think this is arguably the most interesting part for us, was not there when in the room when decisions are made. So if you can pick up on that, and Andrea, and share with us, how do you make your decisions when there are this type of conflicts, particularly in digital markets?
Sure. I think Olivier raises a series of interesting points, which I actually agree. And first, I think it's necessary to make the disclaimer that unlike the CMA, COFECE has only a competition mandate. It's not a consumer protection agency. And I think this becomes very relevant, as Olivier has pointed out, because regarding digital markets, there are not only implications to competition, there are implications to privacy, to consumer protection, to et cetera. And in our case, when we look at cases, we can only look at them from a competition point of view. Given or analyzing the consumer welfare standard as broad or as narrow as it can become, but only on competition basis. And in digital, I think Olivier has raised very interesting points, and as we all know, some firms not only compete on price, they can compete on quality and in other terms that are non-price related. And a point I wanted to raise is also the intersection between digital market competition and transparency, for example, in markets, when addressing the use of algorithms and how they operate and how they use. For example, from COFECE's point of or experience, the investigative authority recently conducted a market investigation into the digital marketplaces sector, and determined preliminary that there are barriers to competition in that market. Now, I can only speak about the public and preliminary findings of this investigation, which are available to all of you, since it's an ongoing case. But in this case, the investigative authority, for example, identified several characteristics that I think are relevant to the discussion, such as the competitive implications of behavioral biases and choice architecture. And in its preliminary finding, the investigative authority identified that the lack of transparency in the way that buy boxes work in this market could be affecting competition, as sellers do not know the variables that are considered by these algorithms when deciding which product to showcase. Also, in this investigation, the investigative authority analyzed the aggregation of other services that are not necessarily attached to the core of marketplaces. Again, this is just, I would say, this is just preliminary. Now there's an ongoing subsequent procedure where all the interested parties can provide evidence, and then the board will decide. And I think the decision that the board ultimately takes will be very interesting. But I think that this case touches upon many of the points that Olivier has mentioned, and again, just to close and emphasize, is the intersection of competition policy and other issues. But again, from COFECE, our mandate is we are just a competition agency, and we have to look at the competition implications of other issues such as privacy, such as non-price features, innovation, etc.
Thank you very much, Andrea. Sarah, over to you again. How do you manage these conflicts under the realm of the wide consumer welfare standard?
So I think, the first point, which very much echoes Olivier's comments as well, is to make sure that we are really capturing the full range of competition effects within digital markets. So again, taking the merger control example, CMA, we updated our merger assessment guidance back in 2021, really with that in mind, looking at those dynamic markets, innovation theories of harm, other types of concerns. Have we got the right analytical framework to capture those? It's not simply price effects. Are we looking at the dynamics of the potential, for example, for a merger to be excluding not just a potential competitor, but a dynamic competitor, somebody who is there providing innovative competitive pressure. So making sure we're capturing that full set of issues, I think, is the sort of starting point, clearly within the mandate of competition and antitrust enforcement. To your question then, Ori, about the sort of potential conflict and the trade-offs, it is interesting, and it is, I think, challenging at times. For us, it's about, again, looking at those intersections. So perhaps a couple of good examples from the CMA. One is an antitrust case that we've had in relation to Google. So this involved a case in relation to Google's withdrawal of the third-party cookies, where there's obviously clear privacy issues at play there. And we thought quite carefully about whether to take that as an antitrust case. We were really concerned that there were competition issues emerging, where it was very important to have the voice and influence of a competition agency shaping how Google were going about doing this. But we also recognized that that wasn't the limit of the issues. There was clearly a very direct intersection with privacy concerns. So in running the case, and particularly now we're in the process, so we have commitments that have been given by Google, and we're in the process of working through those commitments and the application implementation of them. We are working very, very closely with the privacy regulator in the UK, and it's almost, I would say, as close to a joint case as you could get in some respects. And I think that's critical. I don't think we could take that case if we didn't have that specialist input, because what you want to avoid, obviously, in that situation is creating a conflict, creating a tension. You are, again, if go back to our starting point, we have a responsibility to deliver outcomes that benefit consumers, benefit businesses by improving competition, but we can't do that in a vacuum. We can't do that in isolation from considering those wider sort of policy implications. But it's also important to recognise the limits of our own remit. So where we have those opportunities to work very closely with other agencies like the Privacy Agency, that helps a lot. Within the UK, we have something called the Digital Regulators Cooperation Forum. So that is the CMA, the Competition Agency, our Data Protection Agency, our Media and Telecoms Agency, which has responsibility now for the online safety concerns in the UK, and also the Financial Conduct Authority, which does a lot of work in the digital space as well. And so we use that forum very, very actively when we are horizon scanning, when we're looking at issues. We identify potential competition issues, but we can see there's an intersection with some of those other policy areas. How do we work best together? Whether that's a case of, should we take this as a competition case, or should the ICO, the Information Commissioner's Office, take it as a data protection case? Putting out joint statements about how we see the policy regimes intersecting with one another, but also having the opportunity to input on one another's casework to the extent that we can. So I think that join up, that sort of policy coordination is critical. Another good example maybe from the work that we're doing at the moment within the CMA is looking at foundation models, generative AI. So again, we've made it very clear that our remit there is both competition and consumer protection. We're looking at how those markets are developing, how we make sure that the upstream markets for foundation models remain really competitive and accessible. Also, how we make sure that the deployment of foundation models is equally competitive and protects consumers in their engagement with businesses and services using generative AI. But of course, there's a whole host of other policy concerns at play there, and obvious examples: security, safety, and there are real risks. I think that some of those other concerns could trump competition concerns. So take the example of making sure that you have sufficient prevalence of open source models, for example. Concerns around safety, security could push the market in a particular direction. Now, I think we have a real responsibility as competition agencies, not just to take enforcement cases there, but also, Andrea mentioned it earlier, the role that we have in terms of advocacy, to be actively engaged in that dialogue, to make clear that it's not limited to consideration of competition concerns, but it's absolutely critical that competition isn't forgotten in that wider policy debate, and that policymakers, which goes beyond us as an agency, governments and others, are thinking about those intersections, understand those trade-offs and those different considerations. So I think particularly in the digital market space, with the rapid evolution of these markets, with the complexity of that policy intersection that we see, the role for us as advocates as well as enforcers is really important, but also recognizing that with those complexities, we can't be hampered in our enforcement activity. It's still absolutely critical that we take action to protect competition, but we need to do that with our eyes open to the wider policy environment that we're in.
Thank you very much. Before moving to the next and last round of questions, I should say that following this round, we will have the opportunity for Q&A. So please start thinking about possible questions to our panelists. And I would like to take the discussion, to look at things from a bit of a different direction, and to touch upon, again, two areas of relatively new areas of enforcement that challenge perhaps the consumer welfare standard from a different direction. The first one being the labor cases, labor market related cases, when you authorities pursuing this type of cases are targeting, in a sense, or protecting a very specific group of consumer, question mark. Are they consumers? Should they be treated as consumers? The second one, maybe from the opposite direction, the work that many of you are doing on sustainability issues. When there, it seems that the group is much, much wider, or potentially much wider than just the relevant market, maybe also considering some cases consumers outside the relevant market, even future consumers, maybe even consumers or just citizens who are not born yet at the time that you decide on your cases. So, Andrea, I'll give you the opportunity to go first. I know that you've been doing a lot on labor recently in Mexico, so the floor is yours.
Thank you, Ori. I think labor and sustainability are two subjects that become very interesting when you go back to the first question that we were talking about on consumer welfare and has it shifted? Is it applicable or not applicable anymore? Since this shift of competition policy into a broader objective, I think a clear example can be labor and sustainability, but also on how competition policy can actually impact on people's daily lives. So competition policy, the COFECE has been active and has had now some cases related to labor market. And for example, so far, these cases have been cartel cases. One of our biggest and I would say most important case was a few years back, where COFECE actually fined the Federal Football Association in Mexico and 17 of football or soccer. I'll say soccer so that everyone can understand that we're not talking about American football. Soccer, 17 soccer clubs.
I would just urge you not to take sides in this debate.
No. But I would say football/soccer. I'm not taking any sides. I just want to be inclusive so that everyone understands that I'm talking about soccer, not American football. And so COFECE fined the Federal Soccer Association and 17 professional soccer clubs or football clubs for engaging in cartel conduct. And those conducts were two types. The first was a no-poach agreement, where the clubs agreed that they would not hire contract-free players, players who were already within a contract. They would not be hired unless other clubs had their consent that they could hire them. And then the second one, which brings not only the cross-section between competition and labor markets, but also competition and gender equality, was that there was an agreement where the association and the clubs had agreed on a salary cap on the professional female players based on age and status. And so the players that were over 23, their salary cap, these are going to be very shocking numbers, because their salary cap was $120 per month. The players that were under 23, the salary cap was of $30 per month. And the soccer players that were under 17 would not be paid. They would only be eligible for transportation and food assistance costs. I think this case is an example where competition can help improve conditions in labor markets, and where workers can be seen as consumers, or in a sort of way can be seen of consumers within the output of contracting services. And another case we've had is related to non-compete clauses. I would say that the COFECE has been a little bit, I think, stricter related to how we analyze competition clauses in merger cases, we do have our merger guidelines established in which cases or under which circumstances and what qualifications should a non-compete clause comply with when we analyze a merger, in order not to see it as a possible anti-competitive risk. But recently, we've had a case where a non-compete clause was sanctioned as a cartel case. In this case, the commission concluded that the clause was separate and was independent from an operation, and basically the clause excluded two former executives in a company that also had a minor shareholder participation for competing with their former company for 10 years. And so the commission analyzed this case very carefully and decided, doing a careful analysis, that the clause was separate from the operation in which the former executives had to sell off their shares. It could not be seen as part of the operation, and that's why it was considered a cartel case and sanctioned as a cartel case. So I think these two cases, and also how the commission has seen non-compete clauses and analyzed non-compete clauses in merger cases and under, I would say, stricter scrutiny within the years, show that in some way labor markets and workers are a type of consumers, and labor markets can have competition policy implications.
Thank you very much. Moving on to you, Sarah. I know that you've, like the EU in a sense, have been taking really seriously the role that competition policy has in the green transition. And with respect to the question of sustainability, and again, we may need to ask ourselves, what is the standard that needs to be applied when thinking about these broader social goals that we're trying to achieve these days?
Yeah, so we have thought very, very carefully about this. When we set out our sort of strategic priorities back in 2023, we did set supporting the transition to a net zero economy as one of our strategic priorities. Now, it was supporting that transition, and again, this comes back to the point of recognizing the legitimacy of the sort of toolkit that we have, again, for us, competition and consumer protection. So we have sort of three strands to that work. One is very much a consumer protection strand, which is about really making sure that where people are buying green products and services, they're not being misled, and that's a kind of clear consumer protection point. And then on the competition side, the sort of second strand for us is about really that slightly broader kind of advocacy market shaping role, as new markets for green products and services are emerging, making sure they're really kind of grounded in strong competition from the get-go. Work we've done in electric vehicle charging is a good example of that. But then finally, we thought very carefully about the issue that's obviously much discussed around the potential for companies to be sort of deterred from cooperating to achieve environmentally sustainable net zero objectives because they're concerned about breaching competition laws. And I think, in common with many other agencies, we'd heard that concern articulated to us a lot. We'd seen the very good work that the Dutch Competition Authority in particular had done, sort of leading the thinking in that space, as well as obviously work ongoing with the European Commission and others. And we were really concerned, I think this is a sort of shared objective across many of the competition agency community, to make sure that it was absolutely clear that there are many areas where businesses can legitimately cooperate without fear of breaching competition law in that space. And that's really important because I think it's pretty uncontroversial that the kind of market developments and evolutions that are needed to deliver net zero clearly require some degree of industry collaboration. So we've set out guidance that really seeks to put that point beyond doubt. But in doing that, we did also think very carefully about the situation where you have an agreement where there is a sort of net zero benefit or environmental sustainable benefit, but it also comes with some restriction of competition, and how do you manage that trade-off? And we felt that it was important not to go outside the parameters of the legal framework that we have, of our perspective in terms of the impact on competition and the sort of trade-off, the benefit for consumers, but that we should nonetheless take quite an expansive interpretation when looking at that trade-off within the confines of that legal framework. So sticking to the confines of that analytical framework, but being sufficiently expansive when we're considering that trade-off. So both in terms of the temporal element, not being too short-termist when we're thinking about the benefits that would flow from the agreement, because obviously this is a set of issues where there is clearly a sort of medium and long-term benefit from environmentally sustainable agreements and initiatives. So making sure we were sufficiently expansive to capture that temporal element, but also, and for us, we took a very conscious decision to expand our frame of reference, specifically when we were looking at agreements that contributed to net zero, and there were a couple of reasons for that. One was the sort of clear externalities at play here, and some of the benefits that would come from some of the concerns that individual companies might have about a sort of first mover disadvantage and the benefits of encouraging a sort of market shift, but at the same time making sure that we were not, frankly, opening the floodgates in terms of setting a precedent that would suddenly kind of unravel in other situations. So net zero for us was a clear example where you could see some of those externalities, and you could also see and base it on both domestic and international government initiatives and underpinned by legislation to support that transition. So in those situations, in our guidance, we've made clear that we would take account of benefits that flow to consumers outside of the specific product market in question. And we think that that is a coherent framework to apply in those circumstances. But we have done that on a sort of deliberately quite prescriptive basis, because we didn't want, as I say, to set a precedent that opened up to a sort of wider influx of broader societal benefits in other situations that might then be deployed to justify anti-competitive agreements, because I think that, that's clearly getting into quite problematic territory quite rapidly. So that was our approach in relation to sustainability. And then very quickly on labour markets, I mean, very similar to Andrea, we've thought long and hard about this. I mentioned at the beginning that when we framed our kind of outcomes in terms of supporting people, we thought about people as workers as well as people as consumers. But very similarly, we've focused our effort in relation to labour markets really in relation to antitrust, anti-competitive agreements, cartel agreements. So a very similar focus on kind of wage fixing arrangements, no poach agreements. We haven't, in the context of merger control, for example, looked sort of specifically and explicitly at the impact on labour markets as distinct from a competition impact. So you may well have a situation where you can see competition concerns arising, which also might have an impact on workers, but we haven't sort of taken a separate and distinct lens looking at the impact of merger control on workers, which I think would be quite a sort of significant further step to take.
Thank you very much. Olivier, I think you in the EU have struggled with more or less the same questions. You need to address particularly the fair share for consumer clause, and maybe ask yourself, who are these consumers and what may happen if, in a certain case, certain consumers are better off and certain consumers are worse off?
Yeah, nothing is easy in life, indeed. Yeah, well, maybe first to say that the two situations, labor markets and say environmental benefits, display very different characteristics. For labor markets, it's one of the things in which we were lagging behind. I mean, it's clear the lead was with Anglo-Saxon countries. I mean, we pride ourselves for having been at the forefront in innovation theories of harm, but clearly in labor market, we were not driving that movement. We joined relatively late. And I suppose this has to do with, for some time we were struggling with, okay, well, in one case, where is the consumer? well, is the victim of an anti-competitive agreement, i.e. the worker can be assimilated to a consumer. And in the other case, when you're talking about vertical agreements between firms and workers, like non-compete, so where are the two undertakings? So I think these are the type. We have still not resolved the second one, I have to say, in the EU. But for the first one, we now have 4 or 5 non-poach agreement cartel investigations. One is very public because we made a down raid and we made a press release. And a side remark is that ever since we rebuilt our pipeline of ex officio cases, we magically saw the number of immunity applications raising as well. And that includes non-poach agreements. So on this, I think we've decided we treat it like a normal cartel. And the good thing is in a normal cartel, the case law allows us not to dedicate too much time to quantification of effects or identification of the victims and the actual harm. For environmental agreements, there as well you need to distinguish two situations. I agree with everything Sarah just said. I mean, we have exactly the same considerations between, trying not to allow all forms of anti-competitive agreements that are, in the end of the day, greenwashing, but at the same time trying to facilitate agreements that have actually little negative impact on competition and potentially big benefits. But the first category is not that one. I'll come to this one. I'll want to dedicate a bit more time. But you have another category. Is you have actual cartel behavior that are not focused on price. And that has to do with everything we have said before on innovation. Because the necessity to decarbonate necessitates huge investments. All the more that we have procrastinated for quite a long time, so these huge investments now have to be made within a very narrow window of time. But these investments have a characteristics that no other investment has, is they normally do not bring a return. And that is because the consumer doesn't care. I mean, if you have 2 metal bars, then as one has been built sustainably, completely decarbonated, the other one was heavily carbonated, well, they compete on the market. Nobody's ready to pay 1 cent more for the first one. So basically, you have no return. That triggers a number of consequences on the state aid side. I will spare you that. But that means also that firms have the tendency to try to delay these investments because there is not much in it for them. I mean, they couldn't be a true believer, but the truth is it's heavily costly and they're likely not to derive a lot of revenues from these investments. And this is the type of situation we see in some new cartels, like the German car emission cartel, which basically have as a focus delaying innovation because it's costly. So rather than focus on raising your revenues, you focus on decreasing your cost or delaying your cost. And that is, in my view, an interesting dimension of this debate, and also from the point of view of consumer welfare standards. Now back to the other side of the equation, which is basically the balancing between the negative impact on competition and the positive externalities. We have basically chosen in the ECN the same position as the UK. We phrased it a bit differently, but I think the essence is exactly the same. And that is to say that we made an opening in the horizontal guidelines that we issued last year to consider positively agreements that could have potentially anti-competitive effects, but would have clear and measurable environmental benefits. Of course, you run into the very well-known issue, which is not actually idiosyncratic to this type of agreements, and that is that usually when you're balancing efficiencies or positive externalities with restrictions of competition, you end up invariably balancing relatively short-term measurable impact on prices with sometimes longer-term, more difficult to measure, broader impact on a number of other things. And so you end up having to make a judgment call between a basket of pears and a basket of apple. And that relativizes, I would say, the debates around the concept of full compensation of consumers, which is a standard that we chose to keep in our horizontal guidelines, and we chose to keep it as a clear signal that we will not tolerate greenwashing. But the truth is that there is nothing scientific in this. It's very complicated to say, well, consumers, here they're compensated 101%, but here it's only 99%. Nobody's able to do that. In the end of the day, what full compensation means is that the competition authorities, and going forward the judges, have to be convinced that the consumers are compensated enough with the environmental benefit compared to whatever is the harm to competition. And that, I think, is a kind of a common sense approach that works well. It's particularly suited, I mean, you mentioned it, Sarah, to first mover disadvantage. Because indeed, in a number of markets, I mean, if the whole of an industry wants to go further than applicable regulatory standards in terms of, say, decarbonation, as said, it's hugely costly. Consumers do not valorize it yet, or maybe never, but for the time being, not much. And therefore, nobody will do it if it's not certain that the others will follow. So in this type of cases, there could be an interest in allowing, a concerted switch to the next level of decarbonation. Interestingly, though, Mrs. Vestager has made this example and the plea for the industry to come forward in September 2020, and we're still waiting.
Thank you very much, all three of you. We have now time to take one or two questions. The mic will be right here.
Thank you very much. My name is Sarah Biantino, and I want to ask a question about, more specifically perhaps about the EU. Given that the GDP, current GDP in direct digital economy is very small, still, probably regrettably, do you not think that the focus has not been, of competition enforcement in the last year, has not been too much on the direct digital economy and less on what matters, I think, probably to the European consumer, and that is creating a lot of political upheaval at the moment. That is the traditional goods, services and industries that the Europeans are involved in.
I can be quick on this. I don't think if you make a statistic of the decisions, you will probably feel that compared to global GDP, the digital economy is overrepresented. But this is also because it is a pervasive factor of competitiveness throughout the economy. So it's not only about the digital economy, it's about all the rest that is dependent on digital solutions. That would be point one. And point two, I don't think that we enforce less than we did previously, simply because this is not the same bunch of people in other sectors, and in particular in sectors that are maybe what you were thinking about, that have been affected by the recent inflation wave. I mean, if you ask retailers, for example, on the agro industry, whether they think that DG Comp is under-enforcing in their sector, I think this is not their view.
Thank you very much. Please go ahead.
Okay, yeah. I have. Okay. Good morning. My name is Lisa Lofdahl-Gormsen. I'm from the British Institute. I have a question for Sarah. You mentioned briefly labour markets, but we heard from the European Commission they have up to 4 and 5 investigations. What kind of investigations are you doing in labour markets? If you could talk briefly about that. Thank you.
Yes, so we have, as I mentioned, we have a number of investigations that, I mean, both, I think, similar to both Andrea and Olivier, covering sort of wage fixing type issues and no poach agreements. We have a number live. We actually have a number of sort of potential leads for further investigations as well. I think similarly, it's a stone that once you turn over attracts quite a lot of interest. We've also done quite a lot of work with companies, providing guidance to companies, because I think it's an area where, rightly or wrongly, they were perhaps less aware that competition law would apply in quite the same way. So we've done quite a lot of that work too. I mean, the other aspect that we have done, which I think sort of is quite interesting in terms of stepping outside of the enforcement space, is we put out a report a couple of months ago. We've got something called the microeconomics unit in the CMA, which does sort of wider microeconomic analysis, and that was looking at market concentration in labour markets. And that, I think, is, again, it's quite a nice example of how we have a role as a competition agency to do some broader analysis. So we were looking, I mean, interestingly, we were looking at the comparator trend of degree of market concentration, labour market concentration in the UK compared to the US. We all know, I think, that the US has been a sort of front runner of looking at labour market competition issues. In fact, what we saw was that the concentration levels in the UK were quite a lot, had been much more static than in the US, where they'd been rising significantly. We looked at prevalence of non-competes where, you know, like Olivier, I think in the UK, as a competition agency, we would not take action in relation to employer-employee non-competes, but nonetheless it's relevant for the economy, the level and prevalence of those arrangements. We looked at regional trends, sector trends. So it's an opportunity for us as an agency to provide some broader analytics which inform government policy, but also to reinforce the reasons why we would take actions where it's appropriate for us to, using our toolkit.
Okay, one last question.
Yeah, thank you. Andrea Gentilini, question on competition and competitiveness. In particular, there are areas where competition or an excessive number of players is or can be counterproductive in terms of competitiveness of the markets, the efficiency, but also consumer or investor cost. For instance, to deal with fixed cost provided often by regulation that is increased, especially after the financial crisis.
Anyone who would like to take this one?
I'll give it a go. Well, that is a debate. That is the old debate, industrial policy, competition policy. We have it every, you know, it's the Loch Ness monster. Every 20 years it resurfaces. Well, my answer would be normally, I mean, I don't see why competition policy should be preoccupied with this, because in reality, if they are fixed costs that are very high, that means probably the optimum market structure is a relatively tight oligopoly, and the market will take care of that. And that's not a competitive issue, because then the competition should be stronger, actually, with a narrower market structure than atomistic. So in principle, you should not find a case in which we would want to intervene if the market is the one as you described. Of course, normally that is a code for a number of other things that are not really told. I mean, I was struck, for example, by the line of speech, pretty remarkably aligned, to the extent you may wonder whether they colluded, among all the big shots of the telecom industry in Barcelona last week. It's interesting because what they say is, they say basically, oh, look at the American market is great, 3 operators, a market of 300 million, that's the optimal structure. Okay? So then you look at, okay, what are the characteristics of the American market? Do they invest more per subscriber? No. Is connectivity better? The quality of service? No. Oh, sure, the prices for consumers are better. Well, actually, they're higher by quite a distance. So in what respect it is superior? Market capitalization, much better, and dividends. Okay, my take is not really what I'm here to protect. But the second part of the reasoning is even more interesting, because you would think, well, then they would say, oh, well, we want more cross-border acquisitions in Europe so that we can mimic this remarkable US market structure. Well, there's nothing that prevents telecom operators to do cross-border acquisitions in Europe, certainly not merger control regulation. I would love that they do, but they don't. And this is not actually what they ask. If you listen to what they said in Barcelona, they ask for in-country consolidation. So they do not have to mimic. They do not have to mimic the American market. They ask to go for a fragmentation of the single market with a good old monopolization, higher margins, higher prices within national boundaries. So if the debate is genuine, first part of my remarks, no problem with competition policy. If the debate is coded as it is in telecoms, then you can expect that we will disagree.
Any other of the panelists would like to contribute, or? Okay. So before before thanking our speakers, let me just tell you that we're now going to have a 15 minutes break. And Olivier, Sarah, Andrea, thank you so much for joining us today.
Thank you.